High Court Gauteng Judge President Dustan Mlambo is one of the keynote speakers at the University of Limpopo's 60th anniversary celebrations this week. Let's cross live to those celebrations in Mankweng, Limpopo.
As early as the beginning of the 19th century, colonization had established parliamentary sovereignty to characterize constitutional developments in South Africa. This arrangement empowered the white minority government during apartheid to manipulate the law to secure their dominance and exclude the majority of people in South Africa from participating equally in the political, economic, and social activities of the country. Parliamentary sovereignty and the lack of representation of the majority of the population in parliament were the key instruments which enabled the minority government to introduce and maintain the apartheid system. Apartheid was characterized by legislation issued by the government to classify, segregate, and discriminate between racial groups. The National Party government reacted to resistance from civil and liberation movements with increased security measures, which violated basic human rights and the rule of law. Before I forget this, Professor Mafalong, when I talk about civil and liberation movements, you should tell my fellow students that during our time, we missed writing exams because we were involved in protest action. Sometimes we had to write exams of both semesters in a period of 2 months, simply because this university hosted some of the most brilliant human rights-orientated and liberations-orientated minds the country has ever seen. And I think you need to give this institution a round of applause. On many occasions, we had to run out of our residences because the apartheid system had unleashed its mighty machine on us. There's a year when they brought in trainee policemen and they invaded Mzana and they beat those lady students to pulps. I remember those years because that day the university was like a hospital ward. But that was all for you to enjoy the constitutional democracy that we have today. Let me go back to my trip down memory lane. The doctrine of parliamentary sovereignty made it possible for Parliament to make any law it wished, and no institution could challenge the law it made. It is worth noting that the Parliament of the time represented only the interest of the white minority. The courts were precluded from reviewing the substance of an act of Parliament, even where it violated the fundamental human rights of the majority. The review interventions of the courts were limited to procedural inquiries as long as Parliament followed the proper process of passing legislation such law was admissible. Practically, therefore, socio-economic benefits such as social security, education, and healthcare were regulated by law on a racially discriminatory basis. The lives of the black majority were governed through an elaborate system of statutes, regulations, and codified versions of African customary law embodied in legislation such as the Black Administration Act, which allowed the Governor General to banish a native or a tribe from one area to another whenever he deemed this expedient or in the general public interest. Racial inequalities were entrenched through a myriad of political, legal, social, and cultural institutions. The remaining rights in land, such as labor tenancy, which black people had in areas reserved for white ownership and occupation, were eroded through a series of policy and legislative measures. In the economic sphere, the apartheid regime provided full employment to white people through a combination of discriminatory labor market and educational policies, while channeling cheap African labor to unskilled jobs. on the mines and farms. This legalized discrimination was achieved as a result of parliamentary sovereignty, which sanctioned through a structure of laws an unthinkable crime against humanity. The United Nations said this many years ago. You may ask why I'm taking you down memory lane to talk about this. I highlight this to bring attention to the potential of abuse of public power when those who govern are not answerable to anyone, and perhaps even to indicate the significance of our hard-won constitutional democracy. I hope you make the connection. What then is the role of the judiciary in what I'm talking about? At the advent of our constitutional democracy, it was recognized that parliamentary sovereignty was susceptible to abuse and that checks and balances should be put into place to ensure against the misuse of power that was seen during apartheid. As such, with the introduction of constitutional democracy, various institutions were established to counterbalance the public powers of the government. The Constitution established, amongst others, the public office, the public protector, which similarly to the other institutions was created to support constitutional democracy and is subject only to the Constitution and bears the responsibility of ensuring the fulfillment of its constitutional obligations. The public protector is mandated to investigate any conduct in state affairs or in the public administration in any sphere of government that is alleged or suspected to be improper. Yet, and I emphasize this, the office of the public protector too is subject to judicial scrutiny in line with our constitutional arrangements. In recent years, with the growing visibility of these institutions, particularly the Office of the Public Protector and the South African Human Rights Commission, we have seen the function and effectiveness of these bodies being tested and in the public arena. At different times and from different sectors, these institutions have also faced criticism. These reactions are perhaps inevitable in the context of a perceived encroachment by the judiciary in particular on the functions of the different branches and institutions of government. The character of the criticism most recently directed at the judiciary is born from a similar indignation, uncertain or deliberately misconstrued on the authority exercised by one institution over another, in particular the judiciary. What may appear to complicate the situation and certainly render it more nuanced is the particular architecture of South Africa's constitution and the manner in which the judicial authority has been structured in the Constitution. Chapter 8 of the Constitution vests the judicial authority in the Republic in the courts and provides that the courts are independent and subject only to the Constitution and the law, which they must apply impartially and without fear, favor, or prejudice. Of course, and while the independence of the judiciary is a critical cog in the structure of the constitutional model, that independence comes with accountability. We, in the judiciary, accept without reservation the need for accountability. I need not remind you that the Judicial Services Commission has put in place the necessary mechanisms to ensure such accountability. The power and duty created by Section 172 of the Constitution is that the Constitution contemplates and not a power that the judiciary has abrogated to itself. The powers of the judiciary comes from the Constitution. I need to emphasize that. We have not made up those powers. This is what the drafters of the Constitutions deemed prudent in order to advance the system of checks and balances. Further, Section 172 is peremptory and does not afford the court any discretion. Rather, it provides that it is obligatory for a court to declare law or conduct which is inconsistent with the Constitution, invalid to the extent of its inconsistency. I describe these provisions deliberately in order to really set the historical and constitutional context in understanding how courts or the judiciary function and the foundations of their authority. The architecture of the Constitution, as I've stated, contemplates and requires courts to pronounce in constitutional matters on the validity or otherwise of law and conduct.
Ladies and gentlemen, I think it would serve no purpose for us to have our wonderful alumni and speakers and not to listen to them. There is a lot of noise going on. Can we just give them that respect for now and listen?
Thank you, Program Director. Perhaps the audience is telling me to shut up. I will do that in the next 5 minutes. The architect of the Constitution, as I was saying, requires the courts to, amongst others, scrutinize the conduct of the executive and the legislature and test it for compliance with the Constitution. If it is found wanting, the court is obliged to make a declaration of invalidity to vindicate the Constitution. This may, at first sight and in the absence of a proper understanding of the separation of powers principle, appear to be a breach of the principle, but in truth and reality, it is not. In discharging its function, a court does not take over the role of the executive, which is policy making, or the legislature, which is lawmaking, but rather exercise oversight over those functions when they are challenged to ensure consistency with the Constitution. In this regard, courts often invoke the principle of deference on the basis that where other arms of government act rationally in making choices open to them, a court will not interfere simply because the court would have made a different choice. Similarly, courts do not rearrange budgets or decide how money is to be spent, even though some of the pronouncements from the courts have financial implications. None of these instances that I've posted constitute a breach of the principle of the separation of powers, but rather its actualization in the context of the particular constitutional dispensation we have opted for as a nation. An area of considerable public discussion is that of what has been described as the involvement of the courts in the domain of politics. As a general proposition, one must start by recognizing that the constitutional project that is evidenced by the Constitution is largely a political one. That it has been constitutional does not make it any less political. So when courts do their work and give effect to the vision of the Constitution, its transformative ideals and its social, economic, and human rights imperatives, its work may be properly described as the advancement of the political project of the Constitution. The Chief Justice mentioned this much when he spoke recently at the University of the Free State, and he said, and I quote him, "There is a belief that judges should have nothing to do with matters of
There you have it, Judge Dustan Mlambo delivering the keynote address at the 60th anniversary celebrations at the University of Limpopo. Really starting off his address, speaking about the past, speaking about the times where they missed exams at the university as a result of the civil and liberation movements. Also saying that the university produced the human rights orientated and liberation orientated minds the country has ever seen.